This is the subcommittee investigating the Fulton County Jail. Reminder to everyone, our primary focus is looking at the different components involved in operating the jail, whether it be the county commission, the sheriff's office, the prosecutorial group, or the judiciary. And so we're going to move forward with that this morning. But before we do that, I'm going to ask Senator Chuck Payne if he'd be so kind to open this meeting with a prayer.
Yes, let us pray. Heavenly Father, we thank you so much for this day, Lord. We thank you for every gift that you give to us, the breath of life. Lord, we just ask you to lead us and guide us in all that we do this morning and all throughout this day. For us in Jesus' name we pray. Amen.
Amen. Thank you, Chairman. To be clear, I received a few messages last night wanting to confirm that we were having a meeting at 7 a.m. And I want to tell you what, for the thousands of Georgians who are watching this meeting this morning, as they're getting ready for work, they will greatly appreciate it as they're standing around the water cooler with their coworkers, talking about how fascinating it was. And I say all that very facetiously. I'm sure you understand. But our days here in the Senate start early. Myself and Chairman Albers are usually the first two in the building, and we seem to always be chasing the tails of our responsibilities throughout the day. So starting early, I think, is important. And it's been our habit throughout our time here, whether it's a study committee or any other committee I chaired, that we try to get it started as early as possible in the morning. And it's also the nature of the profession that we're all in, whether we're law enforcement officers or prosecutors, judges, or the men and women that work in the jail. The gentleman who let us into this building this morning had worked here all night. So it's just the nature of the profession of public safety. And I appreciate the response of the Fulton County District Attorney's Office when we reached out to them and invited them to come in and explain their role in moving individuals into and out of the Fulton County Jail. And so with that, I would ask the Fulton County District Attorney's Office, please introduce the three individuals that are here today, and then we'll get rolling forth with our inquiry.
All right. First of all, good morning, Chairman Robertson. Thank you for having us here today, and Chairman Alpers. Also, Senators Halpern, Strickland, who I guess will be joining us later, Payne, and at this time. Thank you for giving us this opportunity to speak with you and answer any questions we can to enlighten the public, enlighten this committee as to our role with the jail and criminal justice in this area. My name is George Jenkins. I'm an executive deputy at the District Attorney's Office, head of the trial division. To my left is...
Good morning. Thank you guys for allowing us the opportunity to speak. My name is Kenneth Hutcherson. I'm an executive district attorney with the District Attorney's Office. I head the case intake division.
And to my right is...
Thomas White. Good morning, y'all. I'm a deputy district attorney. I head the non-complex, which is the property and drug crime division.
Just real quick, Mr. White, did you say non-complex?
That's how we've termed it. Yes.
Okay. Yeah. All right. To start with, and I understand, Mr. Jenkins, you'll be the primary here this morning, or is it just kind of a unified thing?
Yes, it is, Jeff.
I think to start with, if you could give us kind of the DNA of the District Attorney's Office as far as number of employees, the difference between ADAs, investigators, things of that nature, so the committee can understand exactly what the makeup is, if you would.
Well, first of all, thank you. And that's a very good question. Obviously, we are the Fulton County DA's office, Atlanta Judicial Circuit, and so we are the largest and busiest circuit in the state of Georgia. We approximately do, I would say, anywhere from 7,000 to 10,000 felony cases per year. So we have a staff that's fairly large, the largest office in the state. I believe we have about, at this point in time, it fluctuates, but between 365 and 380 employees. That's broken down in terms of attorneys, investigators, victim advocates, and legal assistants. And then we certainly have our outreach program employees as well, federal grants and such. Our office is divided essentially right under Madam DA, essentially to 4 different divisions. The divisions are our Major Crimes Division, our Trial Division, our Case Intake Division, and our Special Victims Unit Division. Myself, many of you know my colleague Michael Carlson. He is the executive of our Major Crimes, and Dacia Young is the executive for our SVD. And so, as you can gather from those names, Major Crimes, gangs, homicides, our White Collar Division, our Appellate Unit, those types of units are on the Major Case. Trial Division, I have the complex and non-complex division, which basically accounts for about 75% of the cases that are actually in volume that Fulton County sees. Then you have your SVD unit, which is our human trafficking, sexual assault, child exploitation unit, and those from those type of charges. And then we certainly have our federal grants, our media divisions. And so that's essentially the main focus of our office. We certainly have an investigations division. So each one of our divisions has a chief.
Mr. Jenkins, I want to be clear
I'm
now.
sorry.
You said there were 4 divisions?
4, there are.
Okay, major, trial, intake, and special victims?
Correct.
Is that right? What is the intake?
Intake.
You did the other 3. I was just curious what the intake division's responsibility is.
I'm sorry.
No,
That's
no.
what we call it. The old.
And I want to be clear. We have this room for 120 minutes.
Okay, absolutely.
We have this room for 2 hours,
Okay.
and so we're not in a rush at all.
All right.
And so as we walk through this, as having conversations back and forth,
Absolutely.
it's just So we are 2 hours. There should be plenty of time.
Not a problem.
Yes, sir.
I'll let
All right.
the executive of the
Yeah.
Case Intake Division talk.
Good morning. Thank you guys again. The Case Intake Division is where the cases are initiated upon arrest. Immediately after arrest, within 72 hours, the defendant is brought before a judge and informed of his charges and possibly receive a bond depending on the charges. What we do is we take the cases from there, and our job is to gather all of the evidence that's involved in that particular case prior to that case being indicted. So once the case is indicted, it is essentially trial ready at that point. Our division, so far this year, there's been over 600 felony arrests already in Fulton County. Generally, per year, it's about 11,000, almost 12,000 cases, felony arrests per year. And that doesn't include cases that are transferred up to us from the state court where the person is initially arrested on a misdemeanor. And after their investigation, they determine that the case should be transferred to us.
Okay, thank you. I appreciate that. All right, Mr. Jenkins,
Yes.
back to you.
Okay.
You said there were 4 divisions.
Right.
You explained 3 of them, and then
Right.
and one that I thought might be a little important to the initial part of the process.
Well, that's
Yeah.
the starting process of how, cases come to our office and the process of the criminal justice. And as you can imagine, with any, we have about 55 municipalities here in Fulton County.
Right, and the 365 to 380 employees are divided amongst the 4 divisions, plus some are in, I guess, more umbrella admin positions that kind of are touched by all 4 divisions. Would that be right?
That would be correct.
Like maybe administrative staff, research, things of that nature?
Correct.
Would the primary investigations take place in the intake, from the intake division?
They would. The initial investigation will take place, of course, as you get ready for actual trial.
Right.
More investigation is going to be required on the more serious cases.
Okay. Now that we understand the divisions within the office, what's the overall budget, annual budget of the Fulton County District Attorney's Office?
Do you have one of those numbers? matters. To be honest with
And
you.
listen,
well, okay.
estimates are fine. Nobody's under oath here.
Right.
We're just
No,
trying to-
no,
And if you don't know it, I mean, it's say that you don't have a clue. That's understandable.
Last time there was no, I know there's a budget meeting today, so we certainly will
That-
learn.
that time-
Boy,
that time of year.
they have, it starts at 10 o'clock, so.
Yeah,
no.
if y'all could get those numbers and
we
email them
certainly
over
will.
to us, I would greatly appreciate that. And looking at the budget, I would assume that y'all receive tax dollars from Fulton County. Y'all receive tax dollars from the federal government to a certain extent, and y'all receive tax dollars from the state government.
That would be correct.
Yeah, so if we could get the numbers of the overall budget and just percentages that y'all receive from there. And when I say the federal government, I think primarily what we're looking at are grants and things of that nature.
Okay.
And with that being said, do y'all have a grant writer within the Fulton County District Attorney's Office? Or-
We do.
Okay,
We
all
do.
right, good. Yes, sir. Oh, what number are you on? 8. Yes, sir.
Thank you, Mr. Chairman. Gentlemen, thank you again for being here. Understanding also from a budgetary perspective, based on the size of the circuit in Atlanta, for how we appropriate how many judges are in that circuit, also then comes down to, as an example, my understanding, if you could help educate the committee, is if another judge was added, so does an ADA position and another budget to go with that in order to add to the ability to prosecute and adjudicate cases. Is that accurate?
That is correct. First of all, Senator Albers, thank you for bringing that up. We certainly could use more of everything, to be honest with you. But absolutely, there are just 20 judges in Fulton County, but with 15 that not specialize, but handle criminal dockets. And so it would help to alleviate some of the pressure and some of the, volume of cases that we would increase the number of judges. Certainly, correspondingly, we would need, and it'd be good for us to have more prosecutors from the state. Certainly, and so we can effectively prosecute matters. And let me give you an example. I am originally from Cleveland, Ohio. I was a felony prosecutor in Cleveland, Cuyahoga County before I got here in '05. And so the county, in terms of population, is similarly yoked, as well as the amount of felony cases that we deal with. And as an example, even in 2005, when I first got here, the court size, the criminal bench in Cleveland has 34 judges. And so you have about 1.2 million people that live in the county. I think maybe 4.5 or 5 million people that come in and out daily that may not live here but do business. Unfortunately, some of them do crime here. And so that gives you an example of what the gap is in connection with a similarly busy jurisdiction that I know specifically, and I've been here almost 20 years now. And so we definitely would, in my opinion, in my experience, would need more judges and prosecutors and correspondingly more public defenders as well.
One follow-up question, if I could.
Yes.
And in looking at recent numbers, as you were referencing from the size of the circuit, this is
Sure.
the largest in the state by far. Is that accurate?
There isn't anything close to it, to be honest.
Thank you.
All right, gentlemen. Individual is arrested by the Atlanta Police Department on felony,
Okay.
brought into the Fulton County Jail and booked in. Where does the DA's office come in and walk us through that process?
All right. First of all, thank you for that question as
Yeah.
well. Essentially, he will be waiting for his first appearance as Deputy White indicated in connection with our non-complex and complex. We have a representative there. So that court runs 6 days a week here in Fulton County. That is essentially Monday through Saturday. And which there
How
is
long has that court run 6 days? Has this been a long policy for as long as you can remember?
since I've been here and before.
Is
I
this
think it
is
started-
this a morning court or a afternoon?
It is a morning court. It starts late morning and goes until it's complete.
Okay, Thank you.
Right, and so what happens is that depending on what the type of arrest it was, whether it was warrantless or whether they're with a warrant. And so a defendant arrested for a felony that didn't have a warrant in Fulton County has 48 hours to be present to receive notice of his charges, the probable cause surrounding that charge, and deal with bond depending on the type of charge it is here in the state of Georgia. If it's arrested with a warrant, then you have 72 hours to have that first appearance hearing. And so they see a magistrate with a defense attorney. There is a pretrial. What I mean by pretrial services has where they do a background check on the person that was arrested to see if they're amenable to bond. There's a magistrate informing them of the charges, their rights, and a defense attorney as
Just
well.
real quick, Mr. Jenkins, you're saying I'm arrested on a Thursday, let's say, and I go to the preliminary hearing on a warrantless charge on Saturday, preliminary hearing, if you will. Probable cause hearing is have we moved to that point yet?
It's a first
Appearance?
All stages of probable cause, basically.
Yeah, well,
but
right.
It's not preliminary hearing quite yet.
Okay.
Commitment hearing.
So who does who's doing the background check? Because the background check is to see if I'm eligible for a bond?
Correct.
Is that correct?
There's analysis.
Is that a GCIC, NCIC?
Type of situation. It's
Situation.
pretrial services, if you want to be more specific. Yes.
Yeah, so it's basically a computer check.
Well, there's an individual doing, yes, a background computer check,
Right.
GCIC check on the history, the criminal history of that.
Right. This is an individual within the agency that has the clearance of the Georgia Bureau of Investigations to run criminal history checks on
Absolutely.
everyone who is audited annually to make sure they're not doing their own research business outside
Right.
of the scope of their job.
Certainly.
And also and the point I'm trying to get to is we're not sending individuals out in the community to interview people, any of this other kind of stuff. What we're basically doing is running criminal history, seeing what's in there, and occasionally get a hit on an outstanding warrant or something like that may have gotten lost or misplaced on the front end. Okay.
That and their criminal history, that means are they currently on probation?
Correct.
That type of thing. And so
Correct.
you'll see that. They'll give a report to the court. They'll give a report to the defense attorney and certainly a representative from our office in ADA that is present for that hearing. Now, a long time ago, pre-COVID, there was an actually ADA at the jail. This actually took place in the courtrooms at the jail of Fulton County. But since COVID, it's now done via Zoom, which is, I guess, some of the technological benefits of the pandemic that we deal with. So that's I guess, positive. But no, there used to be, this happened at the physical jail, and it also happens for misdemeanors in state court as well.
Within the courtroom at the jail?
There are 3 courtrooms at the jail.
Right, and so when you had an ADA at the jail, you had to have judges on the bench at the jail?
Absolutely.
And were these judges, were they permanently assigned there, or was there a rotating schedule? Because,
It depended on the years, but there's a rotating schedule of
Okay.
magistrate judges.
yeah, so, but then the point I'm trying to get to is these aren't full-time running courtrooms at the
Oh.
jail where judges would be assigned to,
Well, judges not from Superior Court? No. But
Right.
certainly they have jurisdiction there, but they
Oh,
wouldn't
sure.
physically be there.
right. And to be clear, we're just talking about felonies.
Correct.
Right.
Right now.
And I do understand that occasionally there will be a case that hits the solicitor's office that, we know DUI is a misdemeanor in Georgia unless you get 3.
Right.
And then it becomes a felony, and in some of those cases, they would be transferred over to the district attorney's office. And
Yes.
then possibly some assault cases, once the facts are looked at, could go from a misdemeanor to a felony, and based on information that maybe the officer failed to realize at the time that he or she thought they were making a misdemeanor case.
Correct.
But for the most part, to be clear, all y'all do are felony cases.
Absolutely.
Okay, good deal. All right, if you'll go ahead, you
Oh,
got us.
no,
You got us in the flow.
No,
of,
no. You ask us.
The
anything
individuals
you
at the
need.
jail, and
Right.
now post-COVID, we're doing all this via Zoom.
Via Zoom.
Yes, sir.
And so after that, and so they will bring the defendant out and inform the defendant of the charges, the probable cause for holding them. Is the person that did it, and was there a crime committed? And then bond will be addressed at that time. And
How does the individual, do they have accessibility to the public defender's office at that
they
time?
do. There is a representative there or a private attorney if they're able to contact that attorney to
And-
meet them at the jail.
In y'all's experience, what percentage of the individuals sitting inside the Fulton County Jail have private attorneys as opposed to public defenders?
That's an interesting.
And I think the legal term for that is guesstimate.
Guesstimate.
Is what it is. Would you say a majority or would you say a majority or minority?
We have the number.
At first appearance,
Yes, sir.
less than 1% are represented by private attorneys. By the time we get to preliminary hearings, I can only talk about ORCA preliminary hearings, not all of them, but by the time we get to preliminary hearings, that increases to a little less than 10% are represented by private attorneys at preliminary hearings.
That's a fairly shocking statistic, as we say it aloud. Perhaps one of the things that we could do, and maybe some of our friends at PAC and other groups could help us look at what does that look like across other circuits and states and DA's offices, because for a 1 to 10%, that does seem oddly low to me. Maybe I'm missing something. Thank you.
Well, and I think one of the things is, first of all, attorney access sometimes is an
Correct.
issue, but then the financial constraints that come with hiring a private attorney. Private defense attorneys are not inexpensive, and as opposed to civil attorneys, where civil attorneys draw they get the cream once the case is over and they've won. These defense attorneys, they need their money up front. These are small business owners, and they can't afford to wait till a criminal case has gone through the system before they're paid. And what it brings to light, and something that Chairman Albers and I have discussed in the past, and we discussed prior to COVID, is that our public defender's office is a vital part of this.
Yes.
And many times we find they're as good of an attorney as anywhere, but sometimes the compensation in the private sector is much greater than what they're being paid as being public defenders. We all know some good public defenders that come up there and handle a lot of cases, and sometimes I'm a little concerned about caseloads when it comes to if they're able to put the effort into each individual case that they have. And so now, does the public defenders, do they have an office at the jail, or do they come in like?
Well, they used to be there, and they used to have an office. They still may have an office at first appearance or in the jail, but they are as deeply part of the process as the state is.
So in the Zoom process, is the public defender
Yes.
involved in the Zoom process also?
Absolutely, yes.
Are they with the defendant, or is the defendant on a Zoom?
Yes.
The PD's on a Zoom, and then the DA's on a Zoom?
Correct.
Okay. And the judge is on a Zoom?
Correct.
Okay.
And it's my understanding that the public defenders will meet with those clients prior to getting on the Zoom and inform them of what's about to happen.
Yeah.
In person. They'll meet with them at the jail.
And in the
Or-
real world, and everybody knows this, I watch Dragnet, Adam 12, and Barney Miller. Only 3 cop shows on TV that are even close to being real. But a lot of times, public defender goes in there, they may have 6 defendants that they're representing. And these meetings they have with them are not whiteboard meetings where they're looking at DNA and scientific evidence. They're basically saying, give me the circumstances of your arrest, basically. And, it's a quick conversation to where they can go in there and hopefully convince the judge to set a reasonable bond and get the person out, so then they can further the conversation and get deeper into the case in order to help have the case adjudicated. Would
That's
that be
correct.
true? Okay.
That's correct.
Thank you. Okay, so we're having our Zoom meetings, we've got the public defenders and everybody involved, and then,
All right, and then charges will be read. And this is the reason why you're arrested. This is what we're accusing you of at this time. And then a bond will be set or not set, depending on what they're charged with.
yeah. Okay, and if the bond is set or not set and the individual is not leaving the jail, they either can't afford to, or it's such a crime that the judge is not comfortable with setting a bond, what happens? What's the next piece within your agency?
You want to answer that or no?
Sure.
Yeah.
Go ahead.
After first appearance.
Mr. White, can you pull that mic a little towards you? I'm
apologize,
a
Judge.
whole lot older than I look. Thank you. Objection, yeah. Okay. Okay, I am as old as I look. There we go.
I have no comment on that. Thank you, Chairman. What happens is the court has a schedule where every case, no matter whether bond is set or not, is scheduled for a preliminary hearing 15 days after first appearance. If the person bonds out, then obviously the preliminary hearing is waived. In Fulton County, even if there is a bond set, but the defendant does not make the bond, the preliminary hearing still happens. And so
And would you explain what happens at the preliminary hearing?
the preliminary hearing is the first time that a magistrate judge takes a hard look at the warrants and makes a probable cause determination. At the preliminary hearing, the state calls witnesses. Most often, it's the officer. Occasionally, it will be the victim. Sometimes it will be civilian witnesses. The defense counsel, the defendant, through counsel usually, also has the opportunity to call witnesses. And at that point, the charges are either dismissed or bound over to Superior Court.
What level of evidence is required at that hearing to have the case bound over?
It's just probable cause.
Just probable cause, basically just a preponderance, somebody basically makes a claim.
It's lower than preponderance.
Yeah.
Probable cause is a common sense determination that an offense occurred.
So what would you say the percentage is of the cases that move forward as opposed to those that are dismissed at a preliminary hearing?
Again, I have those for a certain segment of the preliminary hearings. Hang on. I want to make sure I'm not talking out of school. Just almost exactly 85% are bound over. Those that are not bound over frequently are the original charge is not bound over, but another charge, either a lesser offense or a different offense, will be bound over. The most frequent reason that a case is not bound over is the officer fails to appear and answer the subpoena.
Okay, so 85% are bound over. Another of the 15% that aren't bound over, a percentage of those are bound over but under separate or different charges?
Yes.
Okay.
Let me
And-
give you an example.
Yeah, and then some are dismissed because the officer fails to answer the subpoena?
Occasionally, we'll have that.
And then, of course, y'all report that to the law enforcement agency, and they deal with the officer who failed to report for a subpoena.
That's nothing that happens regularly. It happens. I
Yeah.
mean, it's just, but that is not a
Yeah.
chronic issue in connection with.
And then in
our
some
law
cases,
enforcement partners.
the victim comes in and says, backs off whatever the initial statement was, and in some cases,
That
I would think.
That happens in a certain segment of cases frequently, and usually those cases are bound over anyway.
Well, if it's a domestic violence case, the state is the victim, and so thereby they can't dismiss that case, or they're not supposed to dismiss that case, correct?
Usually those are the
Yeah,
cases
I
where
just want to get that out there to make sure people realize we're not letting
Sure.
domestic violence
In domestic
individuals
violence
out.
cases, the state goes forward
Yeah.
with the case. And in those cases, the most frequent times when we'll have a victim come in and recant.
Yeah. And I guess the point I was trying to get at is the 85%, plus we add in the other percent with the change charges. So it's pretty close that every case that goes in front of the magistrate judge, the vast, vast majority of them are bound over. And if these individuals are not out of jail, then they go right back to the Fulton County Jail. Their
correct.
cases just continue to move forward.
That's
This is
correct.
15 days into their incarceration.
Correct.
Okay, good. Go ahead.
All right, so, all right, well, that's it. That's pretty much it, the beginning part of, and then the process is either the case is ready for bound over, and that means are they going to be subject to a Fulton County grand jury, or they're going to be subject to an accusation?
Okay.
Which is like a criminal information or
If you
something
could,
like that.
if you could explain that.
Sure,
And,
sure.
you know, I've just left my preliminary hearing.
Okay.
I've gone back to the jail. I don't have a bond. What's next?
Right, and so at that point in time, I
Well-
don't want to step on my investigation.
He is the biggest guy at the table. I'd be careful.
Right, that is. Good
All right,
man he
so,
is.
so once that happens, case intake will then start to investigate that particular case and gather evidence, getting that case ready for trial. And that is gathering any police reports, any detective supplemental reports, any body cams. And so once that happens, we'll put the case together. And once the evidence is sufficient to prove that case beyond a reasonable doubt at that point, we will say it's ready for indictment and then present that case to the grand jury. Now, the grand jury, the level or the level of proof is not beyond a reasonable doubt. It's still only probable cause. But before we indict a case, we're looking for something in between probable cause and beyond a reasonable doubt. We do not prosecute any case that we feel that we cannot prove at trial beyond a reasonable doubt, and those cases are subsequently dismissed. So part of our...
Do you have an idea what percentage of cases are dismissed at that point?
say 5%
Okay.
will be dismissed at that point.
What molecule on 6? Yeah, gotcha.
What's the average time from that process of building a case?
It depends on the case. Of course, the ultimate goal is to try to get it done within 90 days.
Okay.
But depending on if it's a complex murder case or complex armed robbery or serial rape case, then those cases are obviously going to take longer. If it's something that requires something from the GBI, it's going to take longer because we have to wait on the results from the GBI before we can indict even a drug case. We need those results back.
Okay. Thank you.
So what does the individual do while they're waiting on the GBI to come back?
Well, if they're in custody with or without a bond, then they're going to be in custody until that time. Now, even if the case is indicted, does not mean that person is going to be released from the jail. So you have people in custody that are pre-indictment and post-indictment.
Great point. Explain the difference between pre-indictment and post-indictment.
So pre-indictment is what we're doing in order to get the case ready to present to the grand jury. Once it's presented to the grand jury, then it'll become post-indictment or an indicted case, which is passed along to the trial division.
Right. And how long can someone sit? What do you think the reasonable time, or what we normally experience for somebody to sit in jail without an indictment? And I do understand, and look, we're talking about individuals with no bond and serious felonies,
So with no bond,
or bond or no bond.
okay.
Yeah, because if they can't make bond, it doesn't matter that they have one.
Like I said, our goal is to do it within 90 days. But that may end up being 120 days. After 90 days, then that person, even if they do not have a bond, after 90 days, that person is automatically entitled to a bond. So a bond would have to be set after that 90th day.
And that's any case?
That's any case, even a
What you were
murder.
talking about, a serial rapist, a serious murderer?
Correct.
So after how many days?
After 90 days, that person
After 3 months, the judge is required to give them a bond?
required to give them a bond.
Okay. And that bond can be anything from $1 to 10 million,
It could.
right? Okay.
And so I don't have the actual average that a person will stay pre-indictment because there are lots of factors that affect that number. Just yesterday, we had a case that showed that the person was in custody for, say, 600 days. And it showed that it was unindicted. The charge was unindicted. However, when I looked at it, the person is actually in custody on an indicted murder case. Picks up a new case. It could have been 5 days ago. He picks up that new case, but his in custody time will show that it's the 600 days. It doesn't break it down between, okay, he has a new case while he's in custody and say that unindicted is 5 days. It will show that it's unindicted for the full time that he's been held in custody.
Okay, so there's not a second line for a separate case?
It doesn't
It doesn't
separate
break
it.
them out like
Right,
that?
no.
Okay. But your investigators can see that. If you called somebody in and said, explain to me why John Smith is sitting in jail unindicted for 600 days, they can say, well, sir, he's actually
That was the
indicted.
exact situation.
Yeah, he
I got
was actually
notified.
indicted on the front end, and this is just an additional case that we're just moving through the system.
I got a phone call saying, hey, this guy's been in custody for 600 days, unindicted. And I'm like, that's impossible. And when I looked at it, that was the situation. He's actually in custody on a murder case.
Good.
In the new case, also a serious case that occurred while he was in custody.
I think we're getting to a very important point here, and I believe that the way maybe the numbers are being reported and the information is being communicated out is causing confusion for a lot of folks, right? I think it's from the offender, from the community, from certainly all of us that are involved in this process. Maybe one of the takeaways from today, I don't know if we're going to be able to figure this out while we're all sitting in this committee meeting, is how can we show those in a different way that's easier for people to digest that information? Because some of the numbers from the outside would look very alarming, right? But if there are good reasons why they should be there, we have to figure out a way to portray that and show that to the public differently. So well, maybe it's something we can work on.
And I think the most extreme situation that will show that the person is in custody unindicted is if that person is arrested and prior to being indicted is deemed to be incompetent. That person is then sent to Georgia Regional, and an attempt is made to make him competent to stand trial. So it really doesn't make a whole lot of sense to indict an incompetent person. And so that number can be a very high number.
And help me, correct me, I'm not an attorney, and, you know, at times I do take pride in that.
We don't think you. Chairman Robertson.
Yeah. But there is is there not a statute that requires the state has a certain amount of time to determine whether a person is or is not competent? So in other words, we've all seen One Flew Over the Cuckoo's Nest. Correct. We don't have the option of just holding somebody indefinitely while we're waiting to see if they're competent or not. Is that not correct? I know in Maryland, I think they have like 3 years, which I think is, no pun intended, insane.
Right.
But to hold an individual in custody without any proceedings. But here in Georgia, do we have a standard?
That person would be at Georgia Regional Hospital.
Oh, and it's in my West Georgia Regional Hospital. I used to deliver people there, and I've walked those halls and very familiar with it. But what I'm saying is, if we have somebody that needs to be, that we are concerned about their competency, and I think in all capital cases, competency is one of the things they don't even get to say they're not. We send them, or we have them evaluated. But in these cases, when we send them there, to be, for a competency hearing, is there a clock? We can't just let them sit there, can we?
I do.
Look at him, see there?
Yeah, we all.
Well, I'm curious, that
No,
book
there
he's
is a
got,
clock.
that book he's got's got everything in it, I think.
There is a clock, but there's variables. But go
yeah.
ahead, Tom.
The initial evaluation has to take place within 7 days
7 days of what?
of referral.
Okay.
Okay. And that's just a first cut, 30,000-foot view. Then once the accused is transported to one of the regional hospitals, that hospital has 90 days to make an evaluation. At the end of 90 days, they are required to report back to the court whether the person is in fact competent. If the person is incompetent, is the person, and the standard is, likely to be restored to competency? If they determine that the defendant is likely to be restored to competency, they have an additional 90 days before they have to make another report. If the person is determined to not be likely to be restored to competency, and those cases are frequently where there is some kind of cognitive issue, it's not necessarily a behavioral issue, it's where there's frequently not being restored to competency is frequently a cognitive issue, then the Georgia Regional Hospital has 180 days in order to determine whether or not the person needs to be maintained in an inpatient facility or whether the person is safe enough to be released into the community either with or without support.
Okay, so in 1 year and 7 days, I think's what if my Harris County math kicked in there at some point. Okay, then after a year, and I'll use West Central Georgia Regional Hospital as an example, they determine that the individual is not competent, then they can have that individual held in a facility.
That's right.
For how long?
Once there is a determination that the person is not likely to regain competency and requires inpatient hospitalization, there has to be an annual review.
Right.
And then that person is no longer in the criminal justice system at all. That then becomes the mental health system.
Then where is their case?
Essentially, at that point, their case is placed on, no pun intended, what's called the dead docket.
I know what a dead docket is. And to be clear, a case can be taken off the dead docket.
A case can be taken off the dead docket.
Can be revived off the dead docket. Just because they're placed on a dead docket, it does not remove them from y'all's radar. I mean, they may be on the outside edge, because if it's something where they can be rehabilitated, and of course, this brings up another question. I'm concerned that somebody could be sitting in a mental health facility, and every 12 months we get something back, say they're still not good, they're still not good, and then we have victims out there, no matter what the charge is, that are not receiving any kind of justice at all. And again, a point that Chairman Alberts just made is this information is not common knowledge, and so that's for I guess another committee meeting. But so let's say the individual is determined to be competent, and now they are brought back to the Fulton County Jail. And to be clear, and I don't see the attorney from the Fulton County Jail. She was going to try to make it in this morning or have somebody make it in. But the individual is in custody of the Fulton County Jail. They transport them to West Central. If you were to go into the computer and look at that individual, and I see the Executive Director of Georgia Sheriff's Association back there, Terry Norson, I know he'll correct me if I'm wrong, the jail, the sheriff and them go in the system, and they show that detainee on loan to West Central Georgia Regional Hospital. And so when they do their daily jail population count, They count every soul within the facility, and then there's a separate column where they will show individuals that they are responsible for that continue to belong to Fulton County, but they will show them on loan in different areas, whether it's in another county for another case or whether it's at a hospital being evaluated. Would that be correct?
That is correct.
So that still falls into the population of the Fulton County Jail, that individual. Okay, thank you.
Yeah. No.
Yeah.
In terms of the last point, just think of John Hinckley. In terms of
Do we have to?
right, exactly.
Yeah.
Well,
No, that's a perfect
that's
example.
a perfect example of, and essentially what you're talking about. If someone's deemed to be incompetent, he's civilly committed to the state of Georgia, and so could that be something? I'm going to say a legal term here. I guess you can say from law school, but can you keep him in perpetuity? Pretty much. That means if he's never deemed to be likely to be restored and is a danger to the community, he can be kept forever.
Okay, thank you.
Yeah.
Yeah.
They just don't give. Hey, we can't. We can't.
Well, no, and I
let you back out.
I do understand that, and I think that's probably a fracture within the criminal justice system that we're not going to be able to solve. But it's something that I think needs to be understood when we talk so much in this building about mental health, and we have to be afraid that bad people don't. And I'm gonna go to the other side and probably upset a few people that that evil people do not use our sympathy toward those suffering from mental health in order to avoid the criminal justice system.
Right.
And so I think there's a lot of opportunity there because I think and we've talked to the individuals who run the Fulton County Jail. Mr. Norris and I have had many conversations about the amount of psychotropic medication that is administered in our jail systems today. Absolutely. Everything from just mild cases of depression all the way up to schizophrenia. And I just see a lot of opportunity, while I have sympathy for the legitimately mentally ill, and believe me, we've experienced a lot of that through our career, dealing with individuals who really were out of touch with reality. But also understanding the personalities of a lot of these individuals that would see this as a great opportunity to avoid judgment and justice.
Well, that's why we're here. Just to I would just say, root those and vet those people out who are lying and abusing the system. Do they exist? Yes, but.
And do you have alerts within the system that lets you know that it's time for the next evaluation? That it's time for the next report from the hospital as to whether this person is competent or not?
Well, the first communication is to that judge. That
is it directly to the judge, or is it through the DA's office?
No, it is. We're just we're a party, of course, to that matter. But in terms of HIPAA and those other matters, we are given notice of the hearing in connection with the evaluation, the annual evaluation, but that first contact goes to the court. The court will let us, hey, we're going to set this hearing date. So the defense attorney, the defendant's transported where that person is, the judge is there, and we're going to have evaluation sometimes.
But you still own the jacket. You still own the case, right?
Absolutely.
Okay.
It doesn't just disappear.
And this is part of the case file, correct?
Correct.
Okay, but this is one of those unique things. Instead of you moving it to the court sends it back to you and keeps you evaluated.
How would you say, the court retains the state of Georgia through either Georgia Regional or through Superior Court keeps jurisdiction over that person.
I understand what you're saying, and we don't necessarily need to make it about the mental health case.
Okay.
But once you go in front of a judge and have a hearing, the case still belongs to you, correct?
Absolutely.
And the district attorney's office makes the determination as to whether you're going to move forward with prosecution.
Depending on the question, say for instance, if it's a mental health evaluation, and we certainly believe we will argue based on our evaluation of the report from the psychiatrist assigned to make it a report and a review of, hey, this person is not appropriate for release. We'll put that person on the stand as a witness or anybody else that can give an opinion as to our position.
Do you ever challenge these opinions?
Yes, we do, depending on what those opinions say.
Right. Okay, very good. Okay.
Absolutely.
I've got a question if I could.
Yes, you're on.
Thank you, Mr. Chairman. One of the things that we've been discussing as we've learned and educated this committee on the process is when folks are in the system, I'll just say broadly, sometimes merely getting that date on the trial calendar, on the court calendar, ends up solving and resolving and people coming up with a plea and disposing of those cases quickly. Is that your same impression, that simply sometimes just getting to that point can help to expedite the process?
If I'm understanding your question correctly, what, in terms of efficiency, will help push cases forward?
Exactly.
Well, I mean, more resources to the court, more resources for us.
Sure.
And for the system as a whole. And then some of it is, I can just guarantee you that the more judges we have to spread out the responsibilities of cases amongst the bench, who works very, very hard here in Fulton County.
But I think
Go
to
ahead.
Chairman Albert's point, though,
Go ahead.
getting it on the trial docket,
That's
doesn't that knock some of the rust off of it to where public defenders or paid attorneys want to get more engaged into the plea side of it? Because
Yes.
I think we all know, and my numbers may be a little inflated, but I would say probably 90% of all cases are pled. We're not running jury trials day in, day out in
Right.
every jurisdiction in the United States as we would see on some of these scripted television shows.
Absolutely.
Long-term jury trials are an anomaly in today's criminal justice system.
That's true.
So would the work of the district attorney's office to get these cases on the docket and call John Q. attorney and say, hey, we got John Smith on the trial docket, we're going to see y'all in 45 days. And then he gets with John Smith and goes, hey, look, here's what the deal is. And they come to you and you go to them and y'all start negotiating what you think is fair.
Right. And first of all, thank you, Senator Alberts, for that question to specify the disposition and expedite that process.
That's right.
Obviously, the trial is the last. That is everyone, hey, this is the time to make a decision, going to plea, we're going to try this case. But there's certainly variables that are attached to that in context. And so many times, certainly, our office will, contact times in which we file a motion with the court to place a case on the trial calendar because we need something to happen in this matter. But we're not the only party to these matters, you understand? And so it depends on the schedule, number one, set by the court itself. They are the arbiter or the referee of matters. And so I know, like my Cleveland Browns, they lost in the playoffs. I would want them to, hey, I want to, have this game and I want to win it on this date and time. But the NFL or the league may have some say in when that is addressed, and so ultimately we can bring that to the attention of the court. But the court is the last, I would say, object that sets that matter.
Well, let me roll a hand grenade across the floor then.
Okay.
Is the district attorney's office and the court, is it a push, or is one side, are y'all standing there with cases stacked, ready to get on court dockets, and the court's just not moving? Or is the court have court dockets that have space on them, and y'all are, and this, please don't be offended by this word.
Sure.
Y'all are mired in the process because you got to have investigations. You've got to go through all these cases and make sure that everything is put in order. And anybody that's never stood inside of a DA's office and watched the meticulous process you have to go through may not completely understand. This isn't just grabbing an arrest report and running in front of a judge and saying, hey, Joe did this and blah, 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 and then the case is adjudicated. There's a lot of homework that has to be done. Right. There's a lot of constitutional rights wrapped up in all this stuff. So is there a if we've got to figure out what's slowing the cases down, is the district attorney's office overwhelmed and these things are moving slow? Or is the court moving slow? And when you're calling saying, hey, we've got cases we want to get on the trial docket, they're saying, yeah, we're backed up right now. We don't have room.
All right. Well, first of all, it's a legitimate question. And it's one of, I hate to sound like a lawyer again, but it depends. And what I mean by that is this. There's several variables that go into how quickly a case is resolved. That means the type of case. I can tell you this as I initially started.
Now, what does resolved mean?
Resolve means either a plea or there's a jury trial.
Okay, so it's
Some
adjudicated,
some
right?
kind of
It's done,
adjudication.
yeah,
Correct.
okay.
And so I can tell you that we all need more resources. That means the court. That means our office, the public defenders, and Department of Corrections here in the state of Georgia, probation.
But
Go ahead.
where's the kink in the hose right now? And understand what I'm focusing on is overcrowding in the Fulton County Jail.
I can-
And citizens sitting in the jail that have not been convicted of what they are charged with is the process that we've been discussing this morning, is that just takes so long
Right.
that these individuals are being backed up into the jail, or is the process running as efficiently as it can with the resources that you have, and then when you get it all done, you got them trial ready, and the courts are saying, good job, but you're going to have to wait.
I can tell you this, the number one thing in my experience in 20 years, well, not the one where there's so many different things, is that to relieve the pressure of the volume of cases and defendants and just the process itself, post-pandemic, even pre-pandemic to some extent, it's the fact that Fulton County needs more judges. We just need more judges.
Okay, so your answer to the question is that where we're hitting the wall is y'all have the cases ready, and if we had more judges, there'd be more room and we could get them into onto the trial docket.
I can tell you this.
And look, we're not picking winner. We're going to have the judges come in here and do their thing, and look, they're not going to lock any of us up.
Right.
At least not on this side of the table.
I
But
will, we need,
but
we
but
need more
that
resources.
and,
That's just
and
it.
look, we're all
Right.
friends here.
Absolutely.
And so if we're running into it at there, and I think Chairman Albers alluded to that a little earlier when he talked about how busy Fulton County is.
Yes.
If it's a judge issue, then we need to know that, because the determination of Superior Court judges are made inside this building.
I'll say this to you, that every judge on that bench is working their tail off in connection with their daily responsibilities, criminally and civilly. But I know that because, obviously, these variables that exist, it would be helpful to us in terms of our resources in the DA's office and what's available to our Superior Court judges.
Just one second, please, Chairman Albers.
Oh, no, you finish
Yeah,
your
sure.
thought. Go ahead.
That would help us relieve some of the pressure in terms of getting cases adjudicated faster for the public. But I can tell you that the symptom of our system, the volume of cases, the backlog due to COVID, these are all variables that I guess factor in context how quickly a case gets to trial. And I can tell you that obviously are addressing these matters, and obviously, certainly when it comes to violent crime here in Fulton County and in the state, the more resources that we have and the more focus we have, the better the outcomes will be, as you can see with our prosecutions here of violent crime and gangs. And I'm sorry, Senator Albers.
No, you're
Go
fine.
ahead.
I appreciate it. I didn't want to cut you off. And I think getting back to Chairman Robertson's point, and we'll obviously have the judiciary come in a separate meeting, and they'll be able to present their facts. I actually want to thank Fulton County. They provided us, both Chairman Roberts and I, a pretty detailed report of how that looks today, and even by a per judge as far as moving those cases along, getting those dates set and things of that nature. And I think one of the things that would be helpful to us, again, not right this moment probably, but in the future, is we want to make sure that the statistics that we're getting, whether it be from the county proper, from the judiciary, we want to make sure we're getting the same from you to make sure all those numbers are the same. Because if you look at this in its totality, when people self-report, it's easy to self-report what you see the best numbers to be, right? And if we're going to work on this as a part of the component, could be a staffing challenge as we talked about, we want to make sure that they're all equal. So one of my takeaways would be for Chairman Robertson and I and the rest of the committee is to see those numbers, because I'd like to see, again, what the county gave to us, When the judiciary comes here, what you all see for getting those actually through the judicial part of the system for the Superior Court judges.
And I'm just saying that we all need more resources.
Certainly.
Everybody.
Respect
all
that
parties.
very much, George.
Absolutely.
Thank you.
So,
Well, and one of my concerns would be, and let's say we gave more resources to the Fulton County District Attorney's Office to make the system even more efficient, which we all know each and every day we can be more efficient.
We'd love that.
Then that's going to get more cases ready.
sure.
But if we continue to have the issue within the judiciary, it doesn't matter how many resources we give you, because these people are just sitting there holding their jacket, waiting to go into a courtroom, and the courtroom is not available because you're saying we need more resources in the courtroom too.
Exactly. And I can tell you, it isn't something in which, this isn't caused by the judges. It is caused by volume. And so, as I said, each judge works their tail off in the Superior Court.
In volume is a crime problem, right?
It is.
Yeah. And so, and I think that needs to be pointed out, clearly.
Yes.
That if we could solve the crime problem, and I know there was an announcement a couple of weeks ago where murder rates are down in Fulton County and all that, and that's great. It really is. I don't want to gloss over that. But there's obviously still some problems because the individuals that are there have to be processed, and people are still being victims of crime.
Yes.
I'm having a glass company meet me here at the Capitol today, and they're going to replace the window in my truck, where somebody looked at that truck and thought, that's obviously belongs to some guy in South Georgia, and there's got to be a gun in it. Well, there wasn't, so it worked out good. But if we can crack the nut on the crime problem, then we alleviate the pressure all the way through the system.
Absolutely.
But right now, is the Fulton County District Attorney's Office, is it running as efficiently as it can with the resources it has?
It is.
Okay. And the cases, we're hitting all the marks on the time frames that we're required to, whether it's speedy trial request, whether it's any other case. If anybody is, and the word is the word we've been using, if anybody is languishing there, it is not because of inefficiencies within the Fulton County District Attorney's Office?
I'm not aware of it.
I mean, I wouldn't say it's because of inefficiencies on behalf of the district attorney's office.
Right. I'm not talking about intentional, I'm just saying, yeah.
Right. And of course, resources, again, would help. Just case in point, at one point, there were over 18,000 unindicted cases. And at this point, it's below 10. So I think as far as an efficiency standpoint, we've gotten better as we've gone along.
And real quick, before we get, the 18,000, were those all incarcerated?
No.
Okay,
No.
okay.
That is.
And those are, to be clear, those are individual cases, not individuals.
Correct.
Is that correct?
Correct.
Because some of these individuals have multiple cases.
Exactly.
Right, okay.
Exactly.
Yeah.
And so, from an efficiency standpoint, of course, you can always do better, but doing better comes with learning as you go along. And at this point, I think we are about as efficient as we can be with the resources that we have. Of course, with more resources, you become more efficient and you're able to move more cases through.
Yes.
One of the things that also would help is we're waiting, say for instance, drug cases. That's approximately 23% of the felony arrests in Fulton County.
So I apologize, say that last part again.
Drug arrests.
Yeah.
Approximately 23%, between 23 and 25%.
To be felony drug arrests.
Felony drug arrests.
Associated with other crimes or solely drug arrests?
A large percentage of those are going to involve a gun.
Right,
Or-
okay.
And when I say involve a gun, person is in possession of a gun. Of course, from our standpoint, we can't indict those cases until the crime lab comes back. Initially, that time frame was 4 to 6 months waiting on the results of what that substance was.
You come out the GBI crime lab?
Yes.
Okay.
And so, of course, they could use more resources to speed up that process. Case in point, recent visit to New York, they're processing their cases within a week, and that includes crime lab reports and everything. It's gotten back to them generally within a week.
And I got to ask, how are they doing that?
In-house crime lab.
Okay, that's what I was thinking. 'Cause
And just the way they're integrated with everybody being on the same page. There's one police department, works hand in hand with the DA's office. Of course, we have so many different agencies that contributes to what I will call the inefficiencies that you speak of, because each one of them operates in a different way. And with us trying to gather information from each one of them, we have to do it in a different way. Certain agencies want it done one way. Certain agencies, we have to go through open records in order to get the evidence and to prosecute their
hang on,
cases.
let me, what would you have to do through open records to a law enforcement agency in a case that you're prosecuting?
That's a good question.
Well, give me a good answer.
Well,
Give me an example. And listen, I want to be perfectly clear here. And everybody on this committee is 100% with what you guys are trying to do. But this is not the time to be shy.
right.
If there's an agency that is requiring the prosecutor to file open records requests to get evidence, not only do I think that is improper use of the open records law, but it is a huge efficiency, and it is a problem for the victims of crimes if we're putting a knot in the middle of this process. So there are law enforcement agencies that require the Fulton County District Attorney's Office to file an open records request to receive evidence?
Yes.
Okay, could you tell me what agency has that policy?
The Atlanta Police Department has that agency.
Okay, thank you. Appreciate that.
And so that's part of the
Are there others aside from APD?
I don't know them offhand, but I think there are others.
As a follow-up, that would be another helpful bit of information for us.
Okay.
And I do want to point out, he sounds so much nicer than me, and I do appreciate that. Really quick, I've got somebody who's been standing in the queue for a few minutes. I want Senator Halpern to ask. She has a.
Well, so I was going to ask, and I think you hit it. Are there other, in terms of the GBI and making sure that you've got the information you need in in-house labs, do you happen to know, is Georgia unique in that everything has to filter up to kind of the few crime labs that we have, or is it becoming more of a trend that in-house labs are happening across other states and other jurisdictions?
I think it's happening more and more across other states where the police departments have in-house labs. I think the closest one is Charlotte.
Okay, and then, but that was not going to be the original question.
No,
when
ma'am,
I
go
paused.
ahead.
And we've kind of bypassed it, but when we were talking about the courts and the needs for the courts to have more judges, I did want to just intersect to say that Fulton County, as I understand it, correct me if I'm wrong, our last additional judge was in 2009, and we did just make a request for another one that did get turned down.
And I do know there's a matrix, and Chairman Albers and I are very, very familiar with it, that's used throughout the state of Georgia based on caseloads, based on the number of judges and everything else involved.
Yeah.
And in order to qualify, there's a system set up. And when I look at the list, there's a pecking order, and I know the three that are on there now, and Chairman Albers will correct me if I'm wrong, Fulton County is not one of the three because of the way they process. And I have a lot of faith in the process that they use, but I think it's an important conversation that we have to have, because obviously,
Criteria
and
methodology.
I'm not picking winners or losers, but obviously, listening to your testimony today, the DA's office is moving these criminal cases, getting them, your investigators and from the pretrial and everything, getting it all set to go. and it's not being done. And I'm going to emphasize it for the 15th time. We want to figure out a way that we can have, and look, some of these people are absolutely evil, but they have not surrendered their constitutional rights just because they're evil. Sure. And we are overburdening the men and women that work in the Fulton County Jail when we are not moving cases efficiently out of there. And we talk about information. They are being made the bad guys, and they are not. I don't think there are any bad guys in this process, so we need to work on that. But one thing I wanted to touch on, some of those that are determined incompetent, they are sent back to the Fulton County Jail and held there based on the level of incompetence. Sometimes if it's learning disabilities, some of these other things, so in my experience, some are held there, and then the psych units will come to the jail. And I know the jail that I was involved with, we had a psychiatrist and others that coordinated with West Central Georgia, that they're not necessarily because of bed space and other things around the state. So, and I'll dive a little bit deeper into that. Chairman Payne.
I did have one question, kind of going back, stepping to where we started, but from time of intake through the preliminary hearing, what percentage would you say that there is a competency issue that would slow down the process?
It's less than 1%.
Yeah, I don't, first of all, that exact number I don't have, I don't think we have here, but it is a low amount, just in my experience.
Okay.
Down here for the last 19 years.
And would you say that a lot of times that's initiated by the defense?
Yes.
Absolutely.
Yes.
But by law, if we suspect, we have an obligation to, bring that to the attention of the court and, and delve into that issue. We have that ethical responsibility as prosecutors.
One of the things that we've been looking at, and starting when Sheriff Labatt and his team came in, is benchmarking. How does that look across the state and the nation? And if we look at those kind of four pillars that Chairman Robertson mentioned earlier, you were actually referencing Cleveland, right, in your previous experience. What we're trying to figure out is, okay, who is doing it the same? Who's doing it better? Who's doing it worse? How can we get the lessons learned out of that? What are their best practices? Are they using a better process, a better technology? What is their HR process like as far as staffing the court? What things are being done better? Because, I've always believed the greatest form of flattery is imitation. We don't need to reinvent the wheel. Right. And if somebody else has it figured out, one of the things that we're going to hopefully have as an output of this time in this committee is a different look at what we have and how we can improve that process. So my question, I guess, to the three of you would be, have you done any benchmarking like that or looking at other jurisdictions to see how we could improve?
Like I said before, thank you guys. A recent visit to New York, and we went to 3 of the boroughs in New York. And I think it was Queens. The day before we got there, there was a situation where a crossing guard was run over by a DUI driver. And within 24 hours, the DA, ADA in that office was able to pull up on her screen when this accident happened, that just so happened to be a patrol car sitting at the intersection also. She was able to show us the dash cam from that accident showing exactly what happened. The hospital video of where they went in with the driver who ended up being DUI. The actual administration of the breath test. The demeanor of that driver. And all of this was within 24 hours. And like I said, they can turn around their cases within a week. But again, the integration of their entire system with the police department and the DA's office. If that was to happen here, it would be probably a month before we were able to see that video.
So that's a technology integration
It is.
and process flow issue.
Yes, and that's just one case that happened right while we were there,
And
and it was, to give you a time frame. The accident happened when school was getting out, and we're sitting in their office at 9 o'clock the next morning, watching.
And do we know what tools and technology they are using? And are we now going to look at that as a possibility of using that?
We are looking into it. I don't know the name of it.
It's fine.
Well, they have in the basement of the police department, they have a center down there that will rival any in the world as far as cameras and
Right.
and tracking. In the case you're talking about, the dash cam, it's automatically downloaded
Right.
when the officer either does it or when he or she goes back in near the precinct.
Once they go into precinct, they download all of their stuff.
Right. So the obviously the district attorney's office has access to that. Sounds like possibly unfettered, but because it has to be identified as that case. So is this a software program, case management program?
I think it's a combination of case management and just their ability to share their stuff. The DA's office actually will get an alert of that, and automatically, as soon as it's downloaded, have access to that information.
The intoximeter test, that was given at the hospital?
Yes.
And you said they had the results. They had paper results, or
Well,
they had video of
I-
the actual test?
I don't know how they relate the results.
Yeah.
But the actual administration of the test was on the body cam.
On
and
the
we were able
officer's
to
body
see it.
cam?
Right.
Okay.
Right.
So a lot of this came off resources that the police department had?
Yes.
Such as the camera inside the vehicle, the camera on the officer, and those, okay, yeah. All right, so we've got a case. It's ready to go to trial, and the only obstacle that we have at that point is a position on the trial docket. Okay. How would you say the public defenders, are you finding that most of the time the defense attorney's ready to go?
Absolutely. Look, it all depends, depending on, the nature of the case and circumstances, whether it be the state or the defense. It's just that, obviously, with any jurisdiction, whether you're in Cleveland, New York, you can only try one case at a time. And so the more complex the case, the longer it takes to, resolve through a jury trial. And so that takes the court and the judge away from other matters that they're dealing with in terms of the disposition and resolution and adjudication of other cases. If you're on trial, say for a murder case, I'll give an example. I think a lot of the judges in our jurisdiction have 30-plus murders on their dockets. And murders generally take about a week, many of them longer. And so, and those cases are very serious, our victims and their families. And to adjudicate them, it takes a week to try. And that's 3, 4 days, 5 days, 10 days in which the court has to address that, while other matters not being addressed with, either civilly or criminally. And so, and that's just part of the process.
Right.
That slows things down, for sure.
Let me ask you this, and this came up at one of our last meetings. Do those outside of jail, is there any preferential, or if somebody is being held in the Fulton County Jail, do they take precedence over someone who is out on bond?
Yes, they do.
Exact same charge?
Absolutely.
Okay.
And so, perfect. So if you have a guy that's, out on a armed robbery, it's rare, but they do make bond occasionally. And you have a person that's in jail on armed robbery. That judge was saying we're going on the jail case right now. But the amount of time it takes to try a case, as we are, my colleagues here are veterans in terms of trying a case, it takes about 3-4 days to try a case.
Well, if the case is tried, and I think what we've established is the vast majority of cases are pled.
Right.
So is more emphasis given on cases to be pled within the jail or out on the street, or are they given the same? Because in that case, a pled case, we don't need the resources that we would on a jury trial or bench trial.
You have a comment?
Your comment about the vast majority of cases are pled.
Yes.
That is the drug cases, the shoplifting cases, the more simple cases. I think the example that was given deals with a murder case on the robbery case, which, of course, a murder is going to be a mandatory life sentence. So not many of those are coming in.
That's right.
and
We're talking
airing a
about,
plea.
talking about an armed robbery case.
On the robbery case, the mandatory minimum is going to be 10 years.
Right.
And so not many of those people are going to come in and just automatically plead.
Unless they think they can get the minimum and not get 20 or
Or
something
life.
like that, yeah.
Exactly.
Or life.
So-
Armed
so-
robbery is a capital offense.
So,
Right.
so those cases generally are going to be tried.
Okay. What percentage would you say of those types of cases are in the Fulton County Jail? Armed robbery, serious case, violent cases?
Most of them.
Okay, and look, I mean, that's a great answer, most of them. So if that's the case, are we focusing on those non-cases like that and trying to get those pushed through?
Yes, there are several things that we're doing in order to alleviate those people being held in custody, i.e. we meet with the public defender's office regularly and go through the list to see who we can not just give a bond, but a lot of them are given what's called a UJR, where they're automatically released.
What's a UGR?
UJR.
Okay, what is that?
That's
Judicial
judicial
release?
release, yes.
Oh, unconditional.
Unsecured
judicial
judicial release.
Yeah, I wrote that legislation. I just don't, I always use the full term. Yeah, I'm the guy y'all can dislike for that. But judge can set the bond at $1 if he
Right.
wants to.
And so it's being used
Yeah.
in that sense to
Right.
to alleviate the problem of, say, the drug addict
Mm-hmm.
that's being held. And so that's just one of the things that we do. The other thing is that we're starting to actually attempt to negotiate dispositions prior to indictment. And of course, more resources towards that type of program would go a long way.
Are any considerations given to detainees at the Fulton County Jail charged with crimes that may be suffering some medical condition? Would that expedite the case in any way if knowing that the longer we held the individual in the Fulton County Jail, the greater cost it would be to the Fulton County taxpayer, whether it's kidney dialysis or whatever, and it would cause greater risk to the individual being held there as far as possibility of suffering a major medical issue?
Definitely. When that type of situation is brought to our attention, that case will receive special treatment.
Do y'all communicate well with the sheriff's office when it comes to that kind of things where they say, okay, we've got this case, it's this, and this individual's costing us $100,000 a month, so if we could some way get this individual on the trial docket and get this case moving?
Yes.
I mean, those kind of conversations happen?
Yes.
Absolutely.
Okay. Go ahead, I'm sorry.
Oh, no,
yeah.
what you were saying,
Yeah.
we just have to, and I apologize, Senator Payne. We have to realize overall, sometimes we take for granted, I love the great state of Georgia. Everybody wants to be here in Atlanta.
Sounds like you love Ohio,
Yeah,
but go
well,
ahead.
Well, I'm not gonna lie, I am a Buckeye, but you know,
Yeah.
this red dirt got into my blood veins many years ago in college, and so I tried my best to get back, and I did. So first of all, guys, thank you for having me. But the reality of it is well, these contexts. Atlanta's a popular city. The state is a popular place, and so it's not getting smaller; it's getting larger every day. And so those who live here in Fulton County, those who commit, what I mean by commit, but practice their businesses and their professions here in Fulton County, and so it gets bigger and bigger and bigger. And so, with that, correspondingly, all of our law enforcement partners, that includes, law enforcement, that includes the courts, that includes the public defenders, all of our, it's going to cost more money, I suspect, and because we need more resources to deal with it. And it's, I guess, it's a problem sometimes because of, volume and the amount of crime that we do have here, because we're popular. People want to be in Atlanta, and we love it, but
The good, the bad, and the ugly.
yes.
Chairman
Senator Payne, I apologize for
My
running.
question was, as far as the number of does process, we were talking about the judges earlier and the number of judges.
Sure.
Does that process include consideration of the crime rate in that jurisdiction?
I don't know the exact methodology, the criteria. I'm not.
I mean, if
in
there's
terms
higher
of what-
crimes, there'd be obviously a need for a greater number of judges.
Right. I don't know how that's traditionally been done in Georgia. That's something I need to, obviously, when we leave this meeting, that we're going to be researching in terms of percentages of per capita. But I can just tell you from my experience in connection with just being here, everyone's working and working and working and working. And it's just that the more people we get, the more problems, good and bad, and we're just trying to deal with the bad problems that we have and the resources allocated to them. And everybody needs more. We need more, judges need more, public defenders need more, and so do the Department of Corrections and GBI. And those are all our partners, in these matters.
Chairman Albers.
Yeah, thank you, Mr. Chairman. One of the things we talked about earlier was GCIC.
Yes.
And how we're getting data. There was reports, I want to say probably 6 months to a year and a half ago, kind of intermittently, about the lag with updating GCIC.
Yes.
And because of that, we sometimes, as we're going through the criminal justice process, didn't know if somebody had committed multiple crimes yet, because without having the data in the system, that happens. And I think, some of the examples that were shown through the media were that, someone was then let out, on a very low bond or what have you, that actually had other pretty significant, very serious cases that we shouldn't have done that. So can you help us understand the process with updating GCIC, who does that, how and when, and where we think that stands today?
Well, I'll say, obviously, it starts with, the GCIC itself and the clerk's office, certainly in Fulton County and other judicial counties, for greater accuracy in connection with, suspects or people's criminal histories. I don't know, because I'm not a systems person. I don't know if my, hold on for a second here, in connection with how we better GCIC, I just know that there needs to be greater form of reporting and accuracy of such. How we do that in the state of Georgia, how we do that in Fulton County, I'm open for, but we are all open to do that. It is necessary so we can have an accurate recording as to what they've done. This is a process that we're at that didn't just occur in the last 10 years. This has been going on, since I've been practicing, even before I got here. So,
But
go
in the
ahead.
process, once you adjudicate a case, then the
Right.
case goes to the clerk's office, Superior Court Clerk.
Correct.
Superior Court Clerk has individuals employed by he or she that enter the disposition into GCIC and upload it, of course, into NCIC for whatever the need may be. The primary responsibility of those, even if the case is null-prossed or dead docketed, that stuff is forwarded over to the clerk's office.
It is.
And then individuals, and the term escapes me right now, that are certified to go into GCIC and NCIC, there are two types. Any officer of the court can go in and view GCIC and NCIC, and we'll just stick with GCIC, but only certain individuals within any agency is allowed to go in there and edit or add anything into GCIC. So GCIC within the district attorney's office is a tool used to gather information.
Right.
You do not go into GCIC from within the DA's office and make any changes. It takes I believe it's a TAC officer is what I'm trying to remember.
That's correct.
A TAC officer in the clerk's office or a TAC officer in another law enforcement agency that has the certification through the GBI to go in there and make those changes. So to Senator Albert's point, we need to focus on the clerks of Superior Court making those changes within there. And I believe, and correct me if I'm wrong, the Fulton County clerk, are they the clerk of Superior and State Court, or is it separate?
It's separate.
So the State Court clerk could also go in and make the adjustments coming out of the Solicitor General's office.
Right.
And things of that nature. Okay. And it's not a simple process, but
Right.
if it's not updated, then it deprives the district attorney of the tool needed to make sure when your investigators are running those initial background checks as to whether all that information is correct, or absent. Yeah. All right.
Yeah, Mr. Chairman, it may be helpful for us to bring the clerk in as well.
I think so.
Thank you.
Yes, sir. Question probably for the judiciary, but do y'all find any, is there a system that you understand a flow? Because Superior Court judges also handle civil cases, and the attorneys will correct me, I'm sure, there's no necessarily constitutionally bound time frame on moving a civil case as opposed to moving a criminal case where there are. And so have y'all ran into any issues where there's been delay in the court system while civil cases are being heard as opposed to criminal cases?
No, I in my experience, in my own personal experience, criminal cases take precedent, and that is the main focus in connection with cases that are adjudicated and tried. Obviously, the civil docket is something that's certainly very important, but to our Superior Court, in my experience in Fulton County, criminal cases take precedent over because of the person. Yeah, obviously, a person may be incarcerated or whatever. That is the focus of that court. If, say, for instance, there's a competing criminal docket and civil docket, which you may have,
That's right.
and there is a criminal case for trial or civil case for trial. I mean, obviously, there are factors on how old that case is or whatever, but in my experience, the Fulton County Superior Court will, pick that criminal case because of those factors.
Do
as
Fulton
opposed to
County
civil.
judges, are they assigned to criminal dockets and civil dockets, or do they do hybrid dockets that may have civil and criminal on them together?
No. Well, first of all, of the 15 that are assigned, you have 4, of course, that are assigned to the family court, doing family court, which is divorces and
Right.
those type of things. And then you have your regular civil cases, whether it be medical malpractice, or contract disputes,
Right.
a significant number.
How many judges are assigned to that?
15,
Okay,
16, I believe, 15 or 16.
okay, and how many judges are assigned to criminal?
So the same. So you have criminal judges have a criminal docket and they have a civil docket.
So a single judge will have a criminal docket and a civil docket?
Correct. That they're responsible for. Yes.
Yeah, okay. How engaged would you say the DA's office is with the sheriff's office and the jail operations?
What do you mean by engaged? I mean,
Well, what I'm saying is there coordination? Is there consistent coordination where meetings or whatever, where you sit with the sheriff and he says, right now, my population is here, I need to get it down to here. Can we sit and talk about some of these cases and where they are so I can kind of make some plans for this? Because our tour of the jail has to run.
Absolutely.
And so there has to be maintenance done. And there was a particular time that myself and Chairman Albers were in the jail. They had to move detainees from one area, combine them with detainees from another area so they could go back to this area and clean it up, paint it, correct some maintenance issues so they could move them back. And so, the jail is a living, breathing thing, 365 days a year, 24 hours a day. And so you talked about the New York model, is what we'll call it, and it sounds extremely efficient, but obviously there's great communication between the NYPD and the district attorney's office there. So does the district attorney's office have that kind of relationship with Sheriff Labatt, that you can sit down and the sheriff says, hey, this is my problem? And we talked about the health care issue. I've got 3 inmates that have stage 2 cancers of whatever, or I have this, and this, and coordinate this on a regular basis to try to expedite some of these cases through the system, and possibly have at some point when y'all sit down with the public defender, that's one of the issues that y'all bring forth is your client's in here charged with this, it's this, and this, and we think the best solution to this is this right here. Are those kind of conversations happening on a regular basis, or is the sheriff operating in a silo and the DA's office operating in a silo?
First of all, that's a good question. Go ahead.
I think those conversations happen quite regularly.
Yes.
Are they formal?
Depends on what you mean by formal.
What I mean is Senator Halpern's a really good friend of mine, and she could have a bill in my committee that she wants to get heard. She can see me in the hallway and say, hey, Randy, I'd really love for you to hear my bill. Or she can send me a letter saying, I have this bill number, this, and it's an established
Well,
procedure. She doesn't have to send me a letter. But in this case, if I were the sheriff or the DA and I knew there was an issue in the jail, then I would reach out to my counterpart in the other agency and say, hey, look, every 10 days, I want this person within my agency to meet whoever fills this role in your agency, and let's have a conversation and communicate so that we can make sure we're moving the cases out of there to alleviate the pressure that you have in the jail. And so
I don't think there's a
formal process.
I don't think there's a set formal process, but I do know that there are meetings with the DA, myself, and the sheriff. And then again, I meet all the time with the public defenders, and that could be formal meeting in my office, or it could be an email saying, hey, my client has cancer, and can we either consent to a lower bond so he can be out, or will you consider dismissing the case? So that happens, I won't say on a daily basis, but definitely on a weekly basis with myself and the public defender's office.
Well, I think you bring it up is what they're doing in New York seems pretty smart. And no one despises meetings just for the purpose of meeting than I do.
Right.
But in the criminal justice system, we cannot always be reactive. We have to be proactive in these cases. And if the answer is always resources, then we have to figure out what is the tipping point of those resources. Because we have a problem in government where once we create something, it never goes away. And so if we build the biggest jail, and we expand the DA's office, and we expand the judicial, okay, when we get our jail overpopulation under control, then who sits down and decides who gets laid off? Because we have our problem solved at that point. If we ever solve it, that's what I told, we used to tell everybody, as long as there were criminals, I always had a job. And I said, look, if these folks ever wise up, we're all unemployed. If everybody ever gets smart and starts doing the right thing. And so what we've discovered here in government, and Chairman Albers has been here a lot longer than the rest of us, is it's easy for people to come in here and say, the miracle of Botox, but it can't. But the answer can't always be just give us more people, spend more money. Every year we had to go through and look at every single duty that every single employee we had in our large agency did, and we had to break it down to see if we were getting the absolute best value for the 9 hours that deputy sheriff, that dispatcher, that admin was doing the job. And if we found a position that we found we were getting 3 hours of quality value out of those 9, then we would take those 3 hours, disperse them within the agency, and we would have an inefficiency that would have to be gone. And it's no fun, but it's what the taxpayers expect from us. Mm-hmm. And so to make it a formal process, and listen, I mean, there's no doubt you know what you're talking about, but a formal process is every day, 12 months out of the year, to maintain what we have so we don't run into these upticks and downticks. And I understand crime rates matter. And that's an issue, that's a conversation that we have to have with law enforcement agencies, with churches, with moms and dads, and with schools to tackle the crime rate. because sadly, the DA's office has nothing to do with the crime rate. Y'all have to eat whatever's put on your plate. And so I think as we move through this, I think one thing that we understand, and y'all aren't the first group we've had in front of here, is that y'all are all working for your own mission, and you're not talking to the neighbor, and the neighbor's not talking to you.
Right.
And I think to get to the New York model, which I'm so glad that y'all are being proactive and going and looking at these things, like Chairman Albert said, we don't need to reinvent the wheel. That is the proactive effort that needs to be made throughout the criminal justice system to make sure it runs efficient. So I do think that one of the recommendations may very well be to there has to be some kind of policies where the right hand knows what the left hand doing, because what's working right now is leaving citizens of Fulton County languishing in jail, and this is when they should be in prison. I mean, because we know there's guilty people in the jail, but they're sitting there in a jail's very different from prison, and they should not be sitting there, and the taxpayers of Fulton County who support my fellow senators should not be paying for people to languish in the Fulton County Jail. So I think, communications has to be there, and it has to be formal, because formal is all that works. But are there any more questions from any of the senators? Senator Albers?
Final comment, if I
Yes,
could.
sir.
First off, I want to thank each three of you gentlemen for being here today, for your candor, for the great education. We have a lot of takeaways from this, and I think the one that Senator Robertson, Chairman Robertson was just alluding to, I have a technology background, all right, and there's an order of people, process, and then technology, right? You can't just put a technology system in and expect it to function without having the right trained, capable people, the right process, and then you augment that with technology. That being said, throughout my 30-plus years in the business world, I thought when I worked in the telecommunications world, boy, they were really far behind, until I started doing work for healthcare, and I thought, wow, they're much worse. And I started doing work in the financial markets, and they were much worse than the other two, until I got to government and realized they were way worse than all the other ones put together. So we are typically behind the times. And it's a chance, I also believe, for us to propel forward. Several of us are also doing committee meetings on artificial intelligence, right? Yeah. The good, the bad, and the ugly with that, too. But I'm going to implore all of us throughout what we're doing, and certainly what you're doing, to really be looking at how we can use that better moving forward. And again, I really want to thank you for your time and your candor today, and look forward to following up.
Thank you, Senator Albers, Chairman, and anyone else.
Senator Payne?
I was just going to add to that, just so you know, I've worked in criminal justice for 30 years in state probation, but I'll just say, and I know that in government a lot of times, and all around, efficiency comes out of necessity.
Yes.
But in the government, most often it comes out of a commanding necessity.
Yes.
And I mean, it doesn't, we just kind of get used to, we need to start looking at these issues as commanding necessities, that we start looking at how we can become. It's just like 2020, until we were forced to, nobody was doing the Zoom.
Right.
We weren't using the technology, it was already there.
Absolutely.
And so out of necessity, we all started taking up this new technology that's been there and been just waiting on us to find a reason to use it. So I just think there's the necessity's there. And so let's just keep digging and see what we can make this most efficient.
We all agree, and I can say this, that data and systems theory is a greater part of our job as we grow. We've all been in this profession. We've probably got about 120 years worth of experience sitting, or maybe 90 at this. That's you two, not me, but here, right here, and in our experiences, and we will, everybody's resilient in this state. and all of our partners are. And so we're committed to doing what we need to do. Thank you, guys. If you need us back, we'll be back anytime.
Thank you.
For
Senator
answering
Halpern?
what-
Well, I was just going to say that the thing that really strikes me in the conversation that we've had, of course, is that the crime is, has exploded. So you've talked about the volume, but it's really also the complexity, right, of the
Yes.
cases that you're dealing with. And I think that what I've taken away, too, is that what used to be a routine case is no longer the same routine case. And because the complexity of the cases has changed and that kind of texture of the cases has changed, it really does require us to evolve. And you said the word resiliency, and while that's been happening, it is true. How do we continue to build upon that so that we're using all of the things at our disposal to deal with the new realities of the world today and the
Yes.
complexities that we're facing because of it?
Thank you, Senator. If you guys want to hang around for a minute, I'd love to talk to you after we get out of here. Our friend Sheriff Labatt has come in, and we'd like to ask him if he would to come up and let us throw a few fast pitches at him.
Okay, all right.
Oh, you almost.
Well, my seat's hot. Sheriff, back all right.
That's what happens, Sheriff, when you find parking too fast at the Capitol.
You want us to just have?
No,
a seat
y'all are
back
fine.
there?
Y'all are fine right where you are. I can turn him on where he's at.
Oh, I didn't know. Amen. Okay.
Good morning, Sheriff. Good to see you.
Absolutely. Good morning.
When we, first couple of meetings, we met with your staff and with you and your attorneys and others and had some conversations about the Fulton County Jail. Your staff was kind enough to take Senator Albers and myself for a unpolished tour of your facility, and they allowed us to go where we wanted to go and look at what we wanted to look at. And so we've been curious with some of the efforts that have been made since this committee started. It seemed like there were some things that organically happened. And so just curious what's going on in the jail, how's the overcrowding problem, and just get us up to date, if you will.
So first of all, thank you for allowing me to come before you all once again. Happy New Year to those that I have not had an opportunity to speak to personally. I'm actually glad, one, we're having the conversation, and two, we are poised and have created a cadence since you all's visit with the county, with DREAM, the Department of Asset Real Estate Management, and some of the things. Now, could we do things better? Absolutely. One of the conversations that we had yesterday with our county manager, many of you know, Dick Anderson, was we're going to weekly meet on these, on jail issues, what this looks like, et cetera. And so what we've done every other month now is take our entire command staff, right? If you can imagine when you were back at the major at the sheriff's office, take our entire command staff and do our own audit. Now, we're not responsible for the maintenance of the jail. The county is. Ultimately, it's a team or a collaborative effort that we're doing. So we started a blitz project where we shut down one unit, completely rehab it from stem to stern, and ultimately move individuals into those areas and continue to focus on those things. One of the questions I heard on the way over was, and which has been very successful for us, the collaboration between the sheriff's office, the DA's office, the public defenders, as well as our solicitor general. Talking about the population, as you know, a couple of years ago, we had a high, all-time high coming out of COVID, 3,600 detainees, 600 people sleeping on the floor. Yesterday's count was 2,707. We're trying to get it below 2,600 or 2,600.
Remind us
2,700.
what your bed count is.
So bed count is now, it's still, originally the facility was built for 1,100 detainees.
We understand they doubled the population
Correct.
of the square footage.
Correct.
But
Double bunking.
Right, double bunked, which is
Correct.
a terrible idea. What is your capacity?
So right now, our goal is to try and get the main jail below 1,600. The main jail is 1,707. Overall, we're at 2,700 detainees with outsourcing, et cetera. And so to that, for the first time in the last month, we've not had anybody sleeping on the floor. So we started out as an administration having 600 people sleeping on the floor. Through consent bonds with the help of the DA.
Sheriff, I don't know who all's in the room, but I want to reemphasize again, sleeping on the floor means sleeping on a cot. We call them boats.
Floor device, a boat.
It's a boat.
Right.
It's basically inverted, and there's a mattress, and the individual sleeps on that. They are not sleeping on concrete.
They're not sleeping on
Yeah,
concrete.
correct.
Thank you for that clarification. So there are mattresses that go inside this floor device is the proper term for it.
Correct.
We call them boats.
Yep.
And ultimately, we have 10 boats now that are in the medical unit because people have ambulatory issues, right? So whether they're an amputee or they can't sleep higher. And so our newest goal with the help of the county is to provide medical beds for those individuals and create 5 to 10 cells that are more hospital-like, and ultimately we'll solve that problem as well. But to your very point, when we started as administration over 2 years ago, we had 600 individuals sleeping on these floor devices or mattresses, and so now we have nobody sleeping on these floors. So, and that is through a collaborative effort through the DA's office, through the solicitor's office, the public defender's office, and really looking, if you recall, we created an inmate advocacy unit. That unit combs through every person's record routinely and then take those records to the presiding judge to see how quickly we can move the case. Because, again, if you recall, when I took over as sheriff, we had over 850 people that had been in jail a year or longer and not had a second court case. And so we're in this space or this collaborative opportunity is what we're taking to really treat people more humanely, but ultimately try and speed up the cases. That is the end goal. And so this consent bond program that the DA and the public defenders have been able to utilize has really been helpful to us. And so that's our goal and it does include monitoring systems in many instances so that we are releasing the right people.
Yes, sir. Chairman.
Yeah, Sheriff, thank you. Could you again give me what that top number was before we started working on?
So yesterday it was 2707.
Right.
The top number was 3,600 individuals.
So you peaked out at 3,600.
Yes.
I mean, that's an extraordinary reduction.
It
Extraordinary. I mean, it's like close to 30%.
Right.
And I know that there are folks that are both in the room, but other people who are listening. And I would implore our friends in the media that always like to report the bad news and not the good news, that this needs to be reported, that significant teamwork and progress is in play, and you now are at a capacity that we feel a lot more comfortable with. Are we still working on it? The answer is certainly. Do we all have more work to do? The answer is yes. But we need to make sure that we're showing the good progress that's happening. I want to thank all of you who are part of the process for doing that.
Yeah, absolutely.
Sheriff, you said something about technology. Are you talking about technology within the jail, or are these individuals wearing products when they exit the jail?
So 90% of them are wearing products when they exit the jail.
Okay, who is responsible for those products? Is that a sheriff's office?
So it's this duality space that we live in. So
Right.
under the sheriffs in the state, they control the actual monitoring,
Right.
the contract itself, but then the funding has to come from the county.
That's right.
And-
But it's a condition of release?
Yes.
So it's part of the bond system?
In many instances, yes.
Okay, I mean, it's like we used to do with the old ankle monitor.
Correct.
Where we found that it's $12 a day to let somebody out or much less than that now. $2 a day to let somebody out, or $100 a day to hold somebody in jail.
And the opportunity here, the positive opportunity, the unintended consequence was having us as a county go back and look at where we are. At one point, we had more than 1,300 people on these monitoring devices, but it also gave us an opportunity to have conversation with the judges, people that had been on monitoring devices for more than a year. Where is their case? What does that look like? And those people that are self-reporting accordingly, we could actually take them off because they've shown a pattern of doing whatever the DA wants or the judge has the condition of the bond, and then putting that on someone else and allowing the flatlining of the numbers, right? So instead of having 2,000 people out on ankle monitors, we can stay steady somewhere around 1,300 or 1,400 people, and ultimately continue to your point, pay $5 or $6 a day as opposed to the $103 a day to house an individual.
Yep. Now, are you partnered with the private sector in this?
So the answer is yes. It is
So you're not having to go out and purchase this stuff by yourself?
correct. So
Okay, good.
let me level set that conversation. This predates me, and so as I came in, as I was sworn in as sheriff, there was a contract in place with the county already, and there was only one respondent to the RFP at the time, is my understanding, and so they've ramped up to try and increase services to the sheriff's office.
Well, we used to use the large cumbersome ankle monitors, and then we went to a smaller ankle strap, if you will, that would test for alcohol and everything else, had the probes and all this other kind of stuff. And the stuff I witnessed in your facility that had the healthcare aspect to it, we're still using that kind of stuff, right?
So, no.
Okay,
And
why?
that is caught between the politics
And
of-
I don't want to get into the politics of the county, but,
Right,
Okay,
and that's
I
where it
just-
is.
yeah,
That's
okay,
where it is. And
okay.
so I have turned that over to the law department,
okay.
and here's where I am. I'm a huge proponent of technology,
Yeah.
whether it be wearable or in the facility itself. That will come out in the next few months as to a path forward, and I turn that over to the law department.
Well, and the technology is a force multiplier, just like with the district attorney's office. If we have people out there awaiting trial that are being able to be tracked by free world vendors, as we refer to them, then it helps us with manpower, and it also takes some of the pressure off the courts, takes pressure off the prosecutor's office. And so I think I'm 100% with you on the technology aspect, that we have to leverage technology to be a force multiplier, because I promise you, when you get to the jail this morning, I don't live in this county, but people are not going to be lined up looking for applications to work inside your jail.
You are correct.
Yeah.
You are correct.
And I appreciate that. I want to thank both the groups for showing up. And Sheriff, I'll give you the last word if you have anything else to say.
No, I appreciate it. I really appreciate the opportunity to shine light on what we are doing as a county, but ultimately how we are servicing and providing service for our customers, right? Both those that are affected by incarceration and those families that extensively are affected by their loved ones being locked up. So we have an obligation to provide care and custody. That's our focus. And so we certainly appreciate any opportunity to have the conversation, because the more we have a conversation, the more we can fix things together. And again, thank you all.
Thank y'all. And if no committee member has anything, we are adjourned.
Amen. Thank you.
Thank you, guys.
Thank you.
Good to see you.